Real-time crime centers have become a cornerstone of modern policing, helping agencies connect information faster, improve coordination, and make smarter decisions when seconds matter most. But building or refreshing a center can be complex. Constant Technologies helps simplify the process. Constant has partnered with law enforcement agencies across the country to plan, design, and build real-time crime centers, communications centers, drone operation rooms, and emergency operations centers, spaces that are purpose-built to support today's public safety missions. From American-built operator consoles to advanced video wall systems, we focus on the physical environment and technology infrastructure that brings your data and teams together. Our experienced design team works closely with your agency to create layouts and plans that support current operations and future growth. The result is a command environment where video communications and collaboration come together, helping your team move from reactive to proactive policing. Learn more at constanttech.com and schedule a complimentary design consultation. To get started, contact my friend, Lieutenant Sean Arthur, retired from the Collier County Sheriff's Office, at 239-469-4901. Welcome to The Tactical Pause, the official podcast of the Florida Deputy Sheriff's Association. I'm John Creamer, Deputy Executive Director of FDSA. Each episode, I sit down with law enforcement thought leaders to tackle critical issues shaping the future of public safety. Together, we'll explore key topics that empower law enforcement professionals to navigate challenges, lead with confidence, and advance their careers. Take a pause, gain valuable insights, and lead your career with purpose. Thanks for listening. Welcome back to another episode of A Tactical Pause. I'm your host, John Creamer. If you spend any time in law enforcement, you've probably noticed something about us. We prepare for everything. We carry body armor, medical kits, tourniquets, extra magazines. We train for active shooters, critical incidents, natural disasters. The situations we hope never happen. But today we're talking about something many of us never prepare for. What happens to the people we love if we don't come home? Now, I know this isn't exactly a fun conversation. Nobody gets excited about talking about wills or estate planning, but after more than 3 decades in law enforcement, I've stood beside too many families on the worst day of their lives. I've watched spouses suddenly become responsible for making impossible decisions. I've seen children left with questions nobody planned to answer. I've watched families struggle not because they weren't loved, but because no one ever sat down and completed a few important documents. Today's episode isn't about preparing for death. It's about protecting the people you love. August is National Make a Will Month, so we thought this would be the perfect opportunity to have a practical conversation about estate planning, why it matters, and why so many of us continue putting it off. Joining us today is attorney Kent Showalter from DSK Law and also of LegalShield. So Kent, welcome to A Tactical Pause.
Thank you very much, John. I'm happy to be here.
I'm so glad you're here.
Of course. I appreciate your comment about it's not a fun thing to do or think about, even estate planning, but it's very important. I mean, so people tend to procrastinate. Another reason is just because of cost and the expense. I mean, for some folks, a comprehensive estate package can be up to $4,000. For some folks, it could be for basic packaging about $1,500 up to that amount. So it's very important to get done, but that kind of puts some people off. One of the benefits of the LegalShield plan is that all the documents I'm going to be talking about for the most part today are covered. And so I just want to bring that up. So it's a big cost savings. In terms of the will itself, that is hugely important to avoid what we call intestacy. Intestacy is if you were to die without a will. Some other people think that the estate planning only pertains to assets, money, things of that nature. However, it's beyond that. We'll talk about other documents besides just the typical will people think of that have to be part or need to be part of your estate planning. So one thing without having a will, as I said, it's called intestacy. Now, that could cause your assets to go to someone other than you intend them to. So, for example, a lot of people don't realize that if you're married legally, even if you're estranged, haven't seen each other for 2 decades, that spouse will still have a right to claim under intestacy. Everything would initially go to that spouse. Now, usually the way the scheme works, they call it sometimes the poor man's will. It's a state statutory scheme for distribution of assets. So normally the way it goes is that so if you pass away with a spouse, the funds go to the spouse. If you don't have a spouse, then at that point it usually would go up to your parents, and if your parents don't survive you, then it would go to your siblings. So that's kind of how that works out. But again, that could send things to people that you don't want to receive them. And it also doesn't appoint a representative, because what would happen is whoever would be taking under that state plan, they would collectively have to decide who would be in charge of the estate. So, but the will allows you to control that. Now, with the will, as I mentioned, you can actually name your personal representative. You can also, people don't think about this, but in a will, you can appoint guardians and trustees for minor children that you may have and leave behind. Now, it is important to note that with appointing a guardian, if you are survived by the other parent of the children, they typically are going to be the ones to receive the child. But if that's not the case, you can appoint who you want in the will itself, and that'll be taken into consideration for guardianship appointment of the minor children.
Super important.
Yep. Also, with the trust for minor kids, it's actually incorporated into the will itself. It's not an actual separate trust. But a lot of times, kids, if they receive from your state and you don't set an age for a trustee to have activity over the account, then kids at 18, 21, 25 even sometimes may not have enough life experience to know what to do if they get a windfall of that dollar amount. And so having another adult that you've picked could actually do that and make sure that they're taken care of as you would want them to be.
Yeah, absolutely. So let me ask you this. Why do people hate talking about estate planning?
I think the number one thing is it's just not a fun topic. It's not fun to think about, that happening for a lot of people. Another reason would be that they don't want to hurt anyone's feelings. So someone may not want to be the one want to assign certain things to go to certain people, or want it to be known who they want to receive or who they would want to try and disinherit. So that's another reason sometimes people don't want to go through the process.
That makes sense. And from my perspective, from law enforcement, we plan for things all the time, and we see tragedy every single day, and we know tomorrow isn't guaranteed, probably more than anybody. Yet we probably are just as guilty, if not more than guilty, than the average citizen about not estate planning. In your experience, do you have any idea why?
I really don't. As I've told you before, my dad was in law enforcement. He has his estate planning done. Obviously, I was involved with that, but I really don't know. Again, other than people fear it's expensive. They don't like talking about it. They don't want to feel blame when it actually comes to being as to who receives once they passed away. But it's an opportunity to avoid having any disputes after you've passed away. So those are all factors to take into consideration. I would also say, in terms of not doing it, people think, well, I don't have any real assets. I don't really own anything at this point in my life, which could change. And if you have the will in place, it's taken care of. But also, they think that the will is the be all end all of estate planning. Even if you have no assets, you still have these other documents we're going to talk about that are part of your estate planning that you really need, are super important.
How long have you been practicing law, Ken?
I've been practicing law for a little over 30 years. I've been practicing law with DSK Law and LegalShield members for over 25 years.
I think it's important, too, that we thank you for doing what you do, and especially thank you for coming on the podcast, and thank you for your dad's service. But when we talk about preparing a will or an estate, it's not just legal documents. I mean, you've already touched on it. It's far greater than that. It's about protecting your legacy and protecting the people that are left behind, right?
100%. They used to call it a love letter to your family, basically, that you've taken care of them for all these situations that could happen, and they don't need to get into disputes over that. I will tell you, 28, 29 years ago, the first time I was involved with a litigation over a pending estate and trust, there were three siblings. There were three siblings, and it got to the point, it was like a 12-hour mediation, and just trying to work out things. It got to the point at about 12-hour point, two brothers and a sister were arguing over who would pay for the headstone. That was all that was left. It was a substantial estate. And at that point, I was like, ready to stand up and say, hey, I will pay for their headstone and just to get this resolved for you guys. But yeah, that's another factor, of course.
So, in your experience, I mean, that's a great example of a family grieving that turned in perhaps a family quarrel.
Yeah.
Yeah.
And of course, that's something you want to avoid.
Yeah, and I know, like with many of our listeners, know that my father passed away not too long ago, and then my brother passed away, but neither one of them had a will. Now, my dad had some things in place, but my mother was not on anything. They'd owned a piece of property and a home for since
Mhm.
1970, and when he passed away, we found out that it was in his name only. So, tell our listeners probably what happened to me based on your experience. What did I have to go through?
Here's what I'm going to imagine happened. Well, first of all, let's do the inverse. In the event that they both were on as husband and wife, when the first one passed away, it would go directly to the sole survivor. That's number one. But since that wasn't the case, then an estate would have to be opened up for your father typically. Hopefully, it was determined to be homestead, and then you'd still have to go through the estate administration process to get a personal representative's deed transferring it to you. Is probably what I'm guessing happened. Something akin to that.
Yeah, and I was not prepared. None of us knew that, and again, it was something that my parents had done, the year I was born. So I found out because we were trying to get everything together to take care of mom, and then I had to go. I had to I hired a lawyer, a great lawyer here in Tallahassee, and we went to probate, and it turned out to be a very expensive endeavor.
Mm.
And then from there, we created a will and an estate for my mom and a power of attorney. So, are those things that you would recommend
Oh,
to people ahead of the game?
absolutely. So again, ideally, it's a husband and wife when they take deed to any real property. It should indicate as husband and wife. That way, when the first one passes away, it automatically goes to the survivor. Another option is an enhanced life estate, which is also called a ladybird deed. That going outside your will, for example, if there was property named only in your father's name, he could actually add your name to a ladybird deed. He would still retain all control of the property. He could sell it. He could refinance it if he wants. And if he doesn't do any of those things, then it's going to go to you automatically. But you don't have any say during his lifetime whether or not the property gets sold or if he can refinance. If it's a true life estate, then you would have to be involved in that process. Same thing with joint tenants, which is like husband and wife, except it's people that aren't married. Joint tenants, it goes to the survivor of the two. They both have to agree for filing it in terms of selling a property or refinancing it, things of that nature.
Why do they call it a ladybird deed?
You know what? I honestly don't know because I've always referred to it as an enhanced life estate. That's really what it truly is, an enhanced life estate, because it retains for the owner the ability to cancel at any point in time, basically.
Okay. And then also from my perspective, without getting into great detail, a close friend of mine was killed in the line of duty years and years
Hmm.
ago. The citizens that supported him created a foundation. They had to appoint a trustee, a bank account, all these things. And they're on top of grieving, on top of a death brings out, sadly, the best and the worst in families. So now we had to find the trustee, appoint that person, and then make sure that the family's needs were met, all in the spirit of my friend that was passed away. So it's so important. But from that incident, many things changed. But one of the things that changed was the agency I worked for at the time created a process where all of us, all employees, sworn and non sworn, every year when we had our annual evaluation, we had to update a person of contact, an emergency contact person. We had to update if we had a will, not had a will. From there, the weight behind that process died off and people were forgetting to update their will. And in law enforcement, the divorce rate is very, very high. And then often we saw where the estate would go to somebody that was no longer in the good graces of the person that passed. Do you see that?
Yes, absolutely. Particularly with intestacy, also with a will, even situations. One thing I would first state is the will is only going to control assets that are owned by you solely at the time that you pass away. So, as I mentioned, the ladybird or the enhanced it's life estate. There are other things. For example, anything that you have that's an asset that allows you to add a beneficiary, please do that. Whether it's your life insurance, your 401k, any payable on death accounts, things like that. If you're allowed in the document itself to actually identify a beneficiary, do that because that will never even go through your will. It will never go through the estate. If you have life insurance and you haven't named a beneficiary, same thing with your 401k, it's going to have to go into your estate. And for some people, if depending on the amount of the life insurance, for example, it could increase their tax impact as opposed to Florida doesn't have an estate tax. We're lucky here. However, we're still subject to the federal estate tax, but it's a very large amount that I don't see very often coming up. The federal estate tax is currently $15 million dollars for an individual and 30 for a couple. So I don't usually see that requiring the comprehensive estate planning, but that's just something else to take into consideration. Also, if you name your beneficiary with, for example, life insurance, that's a contract you have with the life insurance company. It doesn't go through the state, which is going to take time because you probably already know you have to file a petition, you have to do service, you have to go through the court, and that takes time. Whereas sometimes, particularly if a law enforcement officer may be the breadwinner for the family, and the loss of that income is going to have a severe impact immediately. And so, if there's life insurance and it goes directly to the beneficiary, at that point it's fast. So they get the money they need sooner than later. I would also mention, in terms of beneficiaries for life estates for life insurance, if you want to appoint want a minor to be a recipient of a beneficiary of your life insurance, that does require a separate trust because a
Okay.
minor under 18 can't receive as a beneficiary. Instead, you have to have a trust that would be the beneficiary of that. Otherwise, they have to go through a custodianship. And again, that's more time, money, and expense that can be avoided easily.
I see what you're saying. And so, just to reiterate for our listeners too, because we want to make this cop proof, and I can say that because I am one. So, your beneficiary is not the same as a will. So, no matter who I have as my beneficiary, that's the way it is, unless they're a minor.
That's
With-
correct. Yes.
Okay. Very important to distinguish that.
Yeah, and it's important to do that. Again, I say anything where you're given the option, whether it's 401k, life insurance, to name a beneficiary, name that beneficiary and keep it current.
Okay. Let me give you a couple of scenarios if you don't mind.
Mhm.
So, for a young deputy that's, let's just say 24 years old, single, no kids, just graduated from the police academy, lives in an apartment, has a pickup truck, a little bit of savings, maybe just started a retirement account, no house, no investments. Does this deputy need a will?
It would depend on the situation, but frankly, I would always say yes. They need to have a will. It may not be applicable at that particular moment in time, but you don't know what's going to happen going forward. For example, they could win the lottery. That would be great. But there are other factors involved with that as well. But again, as I mentioned, without a will, you can identify who would be your guardian for children if you were to pass away, who would be overseeing the money, whatever you have, what little you do or don't have. In that situation, again, the more important documents would be the non-asset, non-material aspects of estate planning, which we can talk about whenever you're ready.
Okay. Let me ask you this next
Yeah.
question that's going to lead right into the estate planning. So, different scenario, a married deputy, two children, a house, life insurance, a pension, two cars, and everything's going great in their life. They're healthy. Do they need a will? I already know the answer, but tell our listeners about that. And then
Yeah,
go to
because
your estate planning.
the thing is, you don't know what's going to happen tomorrow, and there is a need for a will. And again, despite in addition to everything I said before, you don't know what's going to happen tomorrow. There's no reason not to have a will, and so I just can't see any. Nah, I mean, yeah, they should have a will. I agree 100%. It would probably be more important in that scenario than the first one, but yes, they should have a will.
Let's talk about what you're going to say about the
Okay.
estate planning. Yeah, tell me more about that.
Okay, so since I started with the will, let me go ahead and mention trusts just very quickly. A lot of people think that they should or need to have a trust, but they don't know why. And so the first question I normally would ask someone if they think they need a trust, which, like the will, the trusts are covered under the plan. My first question is why? What are you trying to accomplish here? Because oftentimes they don't need a trust. They could use something better like the enhanced life estate, which is a much simpler process. And it's important, even if you have a trust, you have to have a will. And it's kind of will we call a pour over will, which means that anything that you have the trust to cover, you have to transfer to the trust. So, like your home would have to be transferred from your individual name to the trust name. In those situations, you also have to contact any finance company or mortgage company to make sure that they approve the manner in which that's done. Most will not push back and prevent you from transferring it, but some have certain underwriting requirements in terms of how that is worded in the actual transfer to the trust. And so that's something to take in consideration. If you don't contact your mortgage company, for example, that can trigger under pretty much every mortgage in Florida what's called due on sale clause, meaning you've changed an interest in that property, and therefore that's an opportunity for the mortgage company to frankly foreclose, saying that it's due immediately. Okay, so the other documents I was talking about, and I think these are so important. Everyone should have at least two of these three that I'm going to talk about. The one that is very personal, and that is, again, there's a famous case that when I started undergrad, it's from Florida. It started in the court system. I was practicing here, I don't know, at least a decade or more before it worked its way up to the Supreme Court, and it was finally decided. It was called Terry Schiavo. It was about a young lady that passed away, and her husband.
Jeb
I'm
Bush
sorry,
was the governor back then. Yeah, I
I
remember
believe
that.
so. Yeah,
Yeah.
Terry Schiavo case, and so it's very sad. When she passed, well, she didn't pass away. When she basically went into her situation, being in a coma, essentially brain dead and not able to survive off equipment, her husband said that she did not want to have extraordinary measures taken. She wanted to be taken off the equipment. Her parents disagreed. And so that's understandable from both sides, but they disagreed. And so there's litigation to decide whether or not to take her off, for example, the breathing tube and IV feeding. And so that continued for quite some period of time. Then it was determined that yes, they would go ahead and take her off. The husband prevailed in that regard. But then after that, there was the issue of nutrition and IV feeding because that's separate. The statute hadn't addressed that before. So now, if you want a living will, which is against personal, my mom has one, my dad doesn't have one. I don't have one, my spouse has one. So it's just very personal. But in that situation, the state added to the statute that you must also, in your living will, indicate specifically if you want to have food and hydration withdrawn or continued if you could still survive while being off the equipment. So that's an important identification.
Yeah, that was a landmark case. I remember that.
Yeah.
And the reason I remember that was it was like I said, Jeb Bush was the governor, and I was still in Tallahassee, and I'd met him a few times. And I remember that
Mhm.
case came up, and as a young man, I didn't really grasp how the deep that went. So that's a great point. So there's a difference between a will and a trust and beneficiaries,
Yeah.
all different things.
All different things, and then the living will is what if she had a living will, you wouldn't know her name. But because she didn't have a living will, that's why it went through litigation all the way to the Supreme Court. Absolutely.
Yeah.
Now, the other two documents that I think are especially important, even if you don't want a living will, which is fine, even if you don't want to go through the process of a will yet, or you have a will, the two next important documents are a durable power of attorney and a designation of healthcare surrogate. And
Tell
here's
us
why
about
these.
those. I
Yes.
lived through that with my mother. So my mother
Okay.
has some health issues, and I have durable power of attorney, and I'm also her healthcare surrogate. Tell our listeners why that's so important, especially for the older first
Sure.
responders like me that are part of that sandwich generation. Why is that so
Mhm.
important?
Okay, so first of all, the power of attorney is for legal and financial. So one person could have the durable power of attorney. The second person could have the healthcare surrogate, which is for medical. And so one person typically has both, but they can be separated. It's up to the person, the grantor, who they want to give those to. Now, the biggest thing in terms of not having it, if you don't have those two documents, which I'll go in a little more detail, if you don't have the durable power of attorney or the healthcare surrogate, which are very simple, again, it's covered by the plan, but it's very simple. If you don't have that, then you would have to go through a guardianship, which is a court proceeding. It's very, very expensive. It essentially requires that you, wanting to be the guardian, have to file a suit against the person that you want to take care of, and a court would have to determine that person to be legally incapacitated. That goes in the court record. You would have to take guardianship education courses before the court, and you'd have to file an annual report as to any and all aspects of their person and their property. So it's very, very expensive, very lengthy, ongoing. You can avoid that so simply just by having a durable power of attorney and a healthcare surrogate. Now, with the healthcare surrogate, I should point out the way that we draft them, and the laws evolved with both state and federal and HIPAA violations and HIPAA requirements to protect private information. We have it set up so that the person that grants you the authority to make medical decisions is also giving you the authority to access medical records and to talk to your doctors because and it totally makes sense, but because you can't make a decision for someone medically without having access to all the information. And so if they didn't approve that or include those HIPAA requirements, then based on privacy laws, the doctors can say, we need a decision, do we do this or do that? However, we can't talk to you about what your options are and why you would want to do that, or we can't share records as to that. So we prepare it so it includes all the HIPAA requirements. With the power of attorney, I just want to mention real quick, it's important to the power of attorney dies when the person passes away, when the grantor dies. Some people try and use it afterwards, not knowing that unintentionally, and you can't do that. It has no authority once that person passes. The other thing is, I would mention, people don't really know how to sign using a power of attorney, and sometimes they'll mistakenly sign the grantor's name, which they can't do, or they'll just sign their own name. It's long and complicated, but normally when they're signing a check or writing a contract, the durable power of attorney should be signed in a manner that the agent is signing Kent Showalter as attorney in fact for the grantor, and if possible, if you can squeeze it in there under the durable power of attorney date this state. So that's important too.
And we'll be right back. Every day you put your life on the line to protect and serve. Who's protecting you? United Badges Insurance Services operates as a dedicated resource for the first responder public safety community. Serving thousands of first responders, United Badges offers a wide range of products including commercial insurance, group accident and health insurance, and personal insurance such as auto, home, renters, rental properties, vacation properties, boat, motorcycle, RVs, flood, and umbrella. United Badges serves active and retired public safety personnel, public safety agencies, public safety associations, public safety support businesses, and public safety families and friends. Experience the United Badges difference. Call 800-566-5990 or visit unitedbadges.com to request your free insurance quote today. United Badges Insurance Services is a proud strategic partner of the Florida Deputy Sheriff's Association. Applicants are individually underwritten by each respective insurance carrier and subject to insurance policy terms and conditions. Not available in all states. Promotional material for descriptive purposes only. Now back to the show. Yeah, so planning isn't about expecting tragedy. It's about loving your family enough to make life easier if tragedy comes, right?
100%.
So the other thing is in the middle of all these, you're grieving. You're grieving the death of a loved one, or their health has taken a terrible turn, and now you have to make these decisions that are emotional, and you're making it for an entire family. But now, if you're not prepared legally, you're opening up Pandora's box on top of your own grief, right?
Yeah, absolutely. And, as you mentioned that, another issue that we see disputes over would be burial, cremation, things of that nature. Now, those are things that we do not put in a will. What we tell folks to do, because a will, if you were to even consider putting in a will, it's going to take time to file the will with the court, get this court to accept it, appoint some personal representative. By that time, everything's done with. So what we recommend, and I've done this for a lot ever, is the person, while they're alive, they should enter a contract with a funeral home or some provider of that nature as to what they want done. That's their opportunity to set out what they want done. And then that creates a contract between them, their beneficiary, their heirs, and the funeral home. So that's it's an easiest way to deal with that. But we don't put that in a will because it doesn't make any sense practically.
Yeah, that's a great point, though, Kent, because especially down here in the South, right? I mean, there's a lot of people that would never want to be cremated. They want to be, buried intact. And there's other people that are like, I don't care what you do. That's a great decision point or discussion point before it gets, to that threshold, wouldn't you say?
Oh, absolutely, absolutely. And again, we have people after the fact, the survivors, where they fight over what they're going to do with it and who had the right to contact a funeral home. And they did, as you example, they cremated someone when the other beneficiary heir would say that no, they didn't want to be cremated, and so that's very important. So that's just a good way to handle that. Let's see. I was also going to mention in terms of the will, just for general information, it's very important. It has to be executed with very specific state law requirements. So the minimum requirement, A, it has to be in writing, and B, it has to be witnessed by two witnesses. All three of those people have to be in the same room. That's the minimum requirement. However, the way we prepare our wills and how they should be done is a self-proving will, which also requires a notary to be in the room as well, and the notary to notarize the will. What that does is if it's a self-proving will and you were to pass away, then all the survivor would have to do is file it with the court, and then the court's going to deem it approved, the most recent one, because of the fact that it was notarized. If there wasn't a notary involved, it's still valid, but what the court's going to have to require is the witnesses, who you may not even know, like if you came to a law firm or if you went to a bank or something, the witnesses would have to appear in court and say, "Oh yeah, I remember back in 1998 when John Doe," they're not going to remember that. So it's
Right.
important to make it self-proving, and that's how we do that.
Right. Not to, again, going back to the emotion that's going to be involved in
Yeah,
these decisions. I mean, because the emotion can blind the logic. I mean, we see that, right? So,
absolutely.
so Kent, it's also, I was taking notes, right? Because I need to shore up some things in my life. But to me, the five biggest documents we've talked about so far, number one is beneficiaries, the last will and testament, the durable power of attorney, a healthcare surrogate, and a living will.
Yes.
Are there any more that we need to talk about, or?
Those are That's the main skeleton, if you will. As we talked about trust a little bit, and we also talked about the enhanced life estate deed, or putting naming beneficiaries, as you said. Those are the main things I would recommend folks at least consider and discuss. With your will, it's important to note that a copy of your will can still be effective, just as the original will. So we normally recommend that someone keep a copy of their will in a safe place at home, like a safe box, letting the survivors know where that can be found. But also, if they wanted to, they can give a copy to a friend or family member so that they're aware of what's going on, because a copy can still be enforced. The one thing I always tell people do not do is do not put your will in a safe deposit box. The state statutes require that in order to get into a safe deposit box when someone's passed away, is you have to actually first file a lawsuit to get access to this safe deposit box to then get the will. And that just delays everything. It's an additional expense. So don't put it in the safe deposit box. It's not a good idea.
It's a
Um,
great point. Great
yeah.
point.
The last thing I think I was going to say about the will is when we prepare a will, we reference a statute in Florida, which we're fortunate Florida allows us to do this, which says that while your will has to be notarized or should be notarized with two witnesses, your will is not going to set up everything you have. It's not going to say this watch, this rocking chair. It's not going to have all that information. But you're allowed to have sheets of paper with your will that only require a signature and date, where you can say, my watch goes to my nephew, Jackson. My rocking chair goes to my niece, Ashley. And so they can go through that process. And so if you decide today that's what you want and you sign it and date it, put it with your will, that's all good. Then if tomorrow you change your mind and you want to change it, all you have to do is sign and date a new one. The most recent document will be enforced. So it's a
Okay.
simple process.
Okay. Let's talk more about probate for a second.
Okay.
So, why is it so important to avoid probate? Number two, why is there probate? Why does that exist?
Okay. And probate actually means to prove the will. That's where that comes from. But I've referred to it more as a state administration in terms of filing. In terms of avoiding it, I would tell you, unlike other states, we have a pretty streamlined state administration process. And again, we don't have federal or state estate taxes. So that's all positive. So in terms of the probate, it still takes time. And again, ideally, you've made arrangements through the enhanced life estate, through naming beneficiaries, what have you. So usually when the first party dies, typically there's not a need to open an estate. Very rarely, unless like in your situation, one party wasn't named on the deed. Otherwise, there typically wouldn't be a need for that when the first person dies. When the survivor then passes away, that's normally where it comes into play. But for most folks, what they've got is life insurances. They have a home commonly. The home, interestingly, still has to be filed a petition with the court, but that petition regarding the home is usually to determine homestead, and so that's a very easy thing to transfer, and it's protected. Like I should have mentioned earlier, so in terms of the will and in terms of spouses, if you will, whether they're estranged and however that goes, you technically can't disinherit your legal spouse in Florida. We wouldn't do that, but you could put that in your will. You could just omit them as what would be better. But if you don't include your legal spouse in your will, they still have the opportunity to request at least a life estate in your home, or depending on the situation, they can keep the home. They also have the ability to automatically elect, it's called an elective share, 50% of your state. So if you and your wife are estranged, you haven't seen each other for 20 years, and you just don't include her in your will, she could still claim 50% of your estate.
I see. Okay. So, would it be fair to say that probate's not villainous, it's poor planning?
Yeah, it is not villainous. There are other things you can do to limit its impact on the situation. But
Okay.
yeah, I agree with you 100%.
Okay. So, and things we should consider as law enforcement officers are marital status, divorce, children, homes, retirement, 401ks, things like that, right? And potential grandchildren that we may not have yet. All those things need to be factored in this legacy planning, right?
Well, what I tell anyone is if you have a major life estate, like marriage, like divorce, having a children, that's an opportunity to reach back out to us. Again, when we prepare wills or what have you, any estate plan documents, if you change your mind tomorrow, you can contact us back and we will make that change. Hopefully it's going to be that you got married or you just had a new baby. Those are the ideal situations and we can update it. But yeah, anytime there's a major life change, that's when to think about it.
Okay. One of our big sponsors with the Florida Deputy Sheriff's Association is the United Badges Insurance Services, and Alan and Patty Durham are the owners. And one of the things we talk about a lot is shop your insurance every year. And I would imagine the same thing applies here, that every year or so you should probably take a look at what your plans are, right? Your future plans when you leave this world.
It's a good thing to do. I mean, you do your taxes every year. You shop your insurance every year. For example, like medical insurance, we have to do that every year. It's a good time just to look at that to say, oh, I didn't think about there's been a change, or oh, I've changed my mind on something. So that is a really good opportunity to look at that on an annual basis. I think it's reasonable. The other thing I was going to say is, surprisingly, we get folks that the decedent lives out of state. I'm just going to say Georgia. The person that passes away lives in Georgia, but they have a timeshare property here in the state of Florida because we're one of the biggest timeshare states around. That's still real estate. And so what happens, and we see a lot of these, is that they first have to open an estate in Georgia where they live. That's called the primary estate. And once they've opened that, they still have to open a second estate here in Florida for the timeshare, or even if it's just a second property, they have to open a second estate called an ancillary estate. And then they go through a second process. It's usually very, very simple because usually everything's been done in the primary estate, and then that just gets transferred over to Florida just for a judge to basically sign off on, approve on the transfer. It's fairly inexpensive and it's not that difficult.
Okay. Tell me why National Make a Will Month exists. What's the importance of having that every month, every year?
Yeah, it's to encourage folks to do this. It's a reminder that, like you said, it's not something fun to do. You may not think about it, you may put it off, but it's a reminder this is an opportunity. It's kind of like changing the batteries in your smoke detectors whenever that you go fall forward or spring back, or vice versa. It's just an opportunity to that and to make people conscious of it and think about it.
Yeah. Kent, you spent 3 decades helping families during some of the hardest moments of their lives. If you could sit down with every deputy in Florida for just 5 minutes, what's the one piece of advice you'd give them?
My biggest piece of advice would have those 4 documents, or at least 3 of the 4, which would be the will, the healthcare surrogate, and the power of attorney. Again, most important to me really is the non-asset part, which is the healthcare surrogate and the power of attorney. Because if you get in a situation, I can imagine a deputy getting hurt, not being able to make decisions even for a short period of time. This would allow someone to do that on their behalf, whether it's making payments for their home. It doesn't mean it's a spouse necessarily, but a younger deputy may name a parent as their attorney, in fact. So they would still be able to access his account or her account and be able to make payments on their behalf. That would probably be the biggest one.
Okay. It's important to talk about that.
Yeah.
So in this taboo world that we live in law enforcement, we see it all the time. We see death and tragedy, but we don't talk about it at home a lot. What's a good conversation segue to have with your spouse or your partner to start this conversation?
The easiest starting point is like when they're about to have kids or planning to have kids. Obviously, that's a simple way to start that conversation. That's usually when you see they're going to have a conversation, at least in terms of what happens if something happens to both of them. Who's going to get the child? So that's an easy starting point. Beyond that, it's just, it's again a love letter to your family. You're saying, hey, we've got things going on. Let's go ahead and make these arrangements so that our friends and family members won't have to deal with it when we passed away, or at least it limits the amount of time they have to spend while they're mourning.
I see. And from the folks that have come into your office and to your colleagues, the ones that have lived through this, what are some of the biggest mistakes that they wish they could probably have a do-over and correct?
Mm-hmm. So again, not taking advantage of transferring or naming beneficiaries on all those documents, whether it's life insurance or adding a joint tenant to your real estate or even an enhanced life estate. That's usually the biggest one that we see. because all those things can be dealt with without ever even looking at a will. If they've gone ahead and done those other alternatives, it basically allows for transfer by operation of law, meaning they go outside of your will. That's usually the biggest thing. And again, I have to say the power of attorney and healthcare surrogate. When someone contacts us and says, we're in a situation where my mother is incapacitated and we need to take care of her bills, we need to make her healthcare decisions. And my first question is, do you have a power of attorney? Do you have a healthcare surrogate? Do you have those things? And if it's no, then unfortunately the answer to that question is going to be you're going to have to establish a guardianship, and that's going to be very expensive. That's one of the biggest sticker shock and regrets, I think, when people hear that information, have to go through that, and the time taking and having to go through courses. It really, really is a lot. Jumping back to trust real quick, I had forgotten I was going to mention, again, my first question is, why do you think you need a trust? Because it's not normally the case. Typically, again, the biggest ones are tax considerations for the federal estate tax. If you have a very large estate, the second one would be a special needs trust. What a special needs trust does is allows you, if you have a beneficiary that is receiving some type of government benefit for disability, what have you, that you can still leave them something without disqualifying them from continuing to get their benefits. If you just left them individually, some asset or funds in your will, then when they're getting their benefits and you go through the estate administration process, the federal government can freeze the accounts that they're receiving monies from the government until they spend down whatever that amount would be, and then they have to requalify to get those benefits. So special needs trusts are a really important thing. And on a lighter note, pet trusts, believe it or not, are a real thing, because this goes back to another Central Florida case, but you can't leave anything to your pet. You can't leave them, your asset, their property in Florida. So what instead the state put together was doing a pet trust, where it basically identifies and creates a trust for that pet where they will be the beneficiary, or whatever pet you pass away with, and it names who's going to be in charge of those funds and what happens afterwards. That actually came out, that statute, I want to say it was like in the early 90s when I was first started practicing, and a woman in Central Florida had won a substantial amount through the lottery. And so initially she wanted to leave things to her animals. And of course that couldn't occur. Fortunately, they got creative in that situation, and they created basically a trust in general for animal care and things of that nature. But yeah, a pet trust is a real thing.
Yeah,
we've done a couple of
real
them.
Things. Yeah.
Yeah.
What else would you want to add to this conversation, Kent?
I don't have a lot more right now without thinking further about it, but just other than the importance of doing this. And I mean, I don't sell LegalShield. I just happen to be affiliated with working them administering benefits. But I mean, just the cost of having any of those documents is so expensive, and the fact that they're covered by the LegalShield plan, that's kind of a no-brainer. But
that's a great point. So for our listeners, if you're a member of the Florida Deputy Sheriff's Association, you can go to our webpage and determine your county and determine if you have LegalShield. Not every deputy in Florida that is a member of FDSA has that. It all depends on the level of your membership. If you do have it, you can go to fldeputyssheriffs.org and you can determine if you have it or don't. There's also a hyperlink that takes you to LegalShield.com. And you can find out more information, or you can reach out to us. You can also send an email to me at podcast@fldeputyssheriffs.org. So Kent, here's my takeaway. This isn't really about legal paperwork. This is about leadership. We spend our careers protecting complete strangers. Estate planning is one way we protect the people who matter to us the most. It doesn't matter whether you're 24 years old or you're getting ready to retire. If people depend on you, this conversation matters.
Absolutely.
Well, Ken, I just want to thank you so much for coming on our show today. I know sometimes this isn't an exciting topic until you've lived through it, and it's worth its weight in gold. So I hope we get ahead of that. We're happy to celebrate National Make a Will Month, and we hope our listeners that are members of LegalShield can log in and take advantage of that, or if not, they reach out to somebody like you or another a good attorney in Florida and get things set up.
Absolutely. Thank you for having me and giving me the opportunity to speak to you guys. I appreciate it.
I love it. Maybe we'll have you come back for some other issues that come up.
That's a possibility. Not a problem.
All
right. Thank you so much.
Thank you for listening to The Tactical Pause, the official podcast of the Florida Deputy Sheriff's Association. FDSA proudly serves over 25,000 deputy sheriffs across the state with legal benefits, vital training, and financial assistance in times of need. You can listen to previous episodes at fldeputyssheriffs.org. LegalShield.org or wherever you get your podcasts. If you've enjoyed the show, please leave us a review and encourage your friends, coworkers, and those in the law enforcement community to listen as well. To learn more about the Florida Deputy Sheriff's Association and how we serve those who serve, visit our website at fldeputisheriffs.org.